Good afternoon, everyone. Chris Gantt-Sorenson with Haynsworth, Sinkler Boyd Law Firm. Very excited about today. We're covering two topics, one pretty thoroughly and one teasing for an upcoming April webinar. We have exciting news to introduce you to our new law partner and team member. But first, we're going to hear from our expert on immigration law, Garrett Steck. Before we jump to Garrett, I want to, make the note that February is Black History Month. And, I don't know if everyone was intending or recalls when we were doing our webinars based on whatever month it was, but that every month that is a month associated with anything that would fall into protected status or employee relations or DEIB issues is an opportunity for an employer to reach their employees by simply honoring the month in some way. It is an indirect way to suggest that the employer is open to recognizing and appreciating and valuing differences. So don't miss the opportunity. There's all kinds of ways to do this in engaging and enjoyable and non-confrontational ways. And so I highly recommend you don't miss opportunities to bring your people more into the fold, all the people that work for you more into the fold of a workplace climate that is diverse and recognizes and values differences. So with that, Garrett is going to talk to us about immigration.
Good afternoon. Thank you for joining us. Today, we're going to quickly hit a few of these topics, kind of culminating with the H-1B lottery registration and e-filing for H-1B purposes. That's a critical item to be aware of, and the annual lottery starts next month, so we will finish with that. But we will start, Keely, with Real ID on the next slide. So I put this in just as an FYI reminder, is that Real ID was passed in Congress back in 2005, back when I was much younger and less gray. I went to a task force with the state of South Carolina and North Carolina about implementing Real ID and some specifically how it was going to work. And here we are almost 20 years later. It's up, but it's not official and not mandated until May 7th of 2025. There was a 2023 date that was pushed back. So now Real ID for all purposes is effective unless it gets postponed again, May 7th, 2025. And again, realizing that if you don't have a passport, you're going to need a Real ID compliant license or identification card issued by the DMV to enter an airport, federal building, military installation, or a nuclear power station. So next slide. For example, this is South Carolina. You'll notice a little gold star. That's, not consistent throughout, but a lot of states are doing something similar with some icon that signifies Real ID. And again, you can go ahead now and get that if when you apply or renew for your license. If you are not eligible for it or don't want to or don't have the documentation, the license will be stamped not for federal, not compliant with Real ID. So just FYI, it's there, it's next year, but we'll see if it actually goes through after 20 years and becomes mandatory. So that very quick, next slide. So based on, since it's been a while since I've presented with Chris, there's been a new I-9, or there's been some I-9 changes. There's a new I-9 form that's now, since November 1st, it's the mandatory form that you use. The edition date is on the bottom left corner, in 8/1/2023. Next slide, Keely. So we've now gone back to a one-page I-9 form. We were at one page back from 86 forward, and then it went to 2 pages. Now we're back to 1 page. Section 1 and 2 are now on the single page with the signatures and credentials and so forth. But they have added 2 additional pages, 2 supplements, supplement A for the preparer and translator, and supplement B for the re-verification and rehire section. So, initial purposes, you should be using this new form. In South Carolina, you're also required to e-verify. If there's any rehire or re-verification for immigration purposes, they'll be using and attaching a new supplement. Form can be filled out again electronically, tablet, mobile devices. It can be electronically created, or you can actually still print the form online. Next slide. This is just one of the supplements for Supplement B re-verification. You'll notice that there's multiple re-verification sections, whereas the old I-9 form only had one section. And then if you had to re-verify a second time or later or rehire, you'd have to go to a new form, and that form would need to be current. Here, it looks like you're provided at least with 2 or 3 sections that are clear. So next slide. General changes, the biggest one up top in section 1, the government has now said instead of an alien authorized to work, you're now a non-citizen authorized to work, which is different than a non-citizen national. So again, there's still the 4 categories of U.S. citizen, lawful permanent resident or green card holder, non-citizen national, and then a non-citizen authorized to work. So the non-citizen national is the individual born in American Samoa and other former trust territories in the Pacific Islands and their children. Non-citizen authorized to work is the old alien, which is a foreign national or non-immigrant that is here in some sort of employment-based visa classification or holds independent employment authorization. But basically that box is for someone that does not have full and unrestricted employment in the U.S. and still entering the information, whether it's USCIS or A number, the current I-94 or a foreign passport. Next. So you can see this is the section from the top, section 1 of the new I-9. You see the 4 boxes, and then if you check item 4, you can enter 1, 2, or 3 of that extra information. So next slide. Also note that I guess now this would be second page, contains the list of documents, list A, list B, and list C documents, which you can present to a new hire. You cannot ask for specific documents, but you can give them that list. They've now amended that list to include acceptable receipts. In some instances, you can accept receipts for something, from a list A, list B, list C document. It's only temporary. You need to have that individual come back and provide the actual document in the future, but that does give a little bit more clarification. You'll note that in the acceptable receipts box may be presented in lieu of a document. For receipt validity date, see the M274. That is the government's, I guess, encyclopedia for I-9 purposes. For a 1 or 2 page form, it's about 100 pages. It gives you all sorts of examples on how to complete the I-9, different situations, special situations, i.e. receipt notices, specific foreign nationals that might be able to work incident to status, i.e. if they're still in school. It's a very good resource. You can Google search it. I used to always say that it was, you have to look for it because the M274 is an older military vehicle, so you get a lot of false hits. It's also a Mercedes-Benz 4-cylinder engine, so you have to dig for USCIS M274. But nonetheless, it is a very good resource that can help in a pinch, even gives copies and examples of documents, green cards, EAD cards, etc. Next slide. So the other big change in the I-9 world is the remote I-9 form document inspection, which was sort of started during COVID for remote workers. People were not in the office, so it's hard to meet with your new employee or your new hire and inspect the documents. So that seemed to work, I guess, rather well. So they've implemented the remote document inspection process. So employers can remotely examine employees' I-9 documents, provided they're enrolled in good standing in E-Verify, which in South Carolina is mandatory for all employers. If qualified, the employer chooses to offer the alternate procedure to some employees, then you must consistently do it for all employees. You can't single out just an individual. But what we usually see or recommending is that, look, if we have people who are on site, we want to do this on site. But if we have people who are remote workers, I've got a number of clients where we have people working all over the country. So for people on remote hires, we use the document inspection. And then next slide. This is sort of a flow chart. It's going to be hard to see, but generally it's from the government, and it says you've got E-Verify enrollment. Yes. Remotely examine the documents, which were provided to you by the new hire. They have to be the same documents presented during the live video. They can't give you a passport and then provide the driver's license and social security card. Then you'll notice it says on the I-9 form, and this is an older, well, I'll say it's current from the government's website, but by date and usage and mandatory requirements on the I-9 form, you're using the new I-9 form. You'll notice both on the list A, list B, list C document list, in yellow highlight, there's a box you check if it was remote inspection. And then below is the supplement for rehire and re-verification. There's also a box in the bottom right-hand corner that you check if it's remote document inspection. And then again, once everything's completed, then you file your I-9 in accordance with your current practices. And then obviously once the I-9 is done, you use that information, then you create an E-Verify case. And then if the E-Verify case is results in employment authorized, you can either print out the confirmation and retain that with your I-9 materials, or you can simply on the front page or the main I-9 page, you can write the E-Verify confirmation number down. So those are the two changes that have occurred in the last few months with the I-9. Just make sure you're using the correct form, which again is the August 23 form in the bottom left corner. Note that there are individual supplements. And then obviously now for remote document inspection, there are the two boxes that you'll check. So next slide. Okay, we will start just a quick overview. Historically, with a few exceptions for diplomats and some other visa categories or classifications, visas are issued through the Department of State at a U.S. embassy or consulate general at somewhere in the world. A visa is a document that allows a foreign national to enter the United States in a particular classification or category. And that could be student, that could be visitor or tourist. It could be a number of employment-based visas. It could be even law enforcement, testifying at a hearing, bringing in a witness. It could be for students. It can be for interns. A lot of different visa classifications. So the visa, if someone is outside of the United States, they have to present a valid passport and a visa to enter the United States. At customs, that individual is inspected, which means their credentials are confirmed and they're reviewed and confirmed. And then the individual is admitted in that visa classification, and they are given an authorized period of stay, which is evidenced by an I-94. So a lot of times there's some confusion between what is a visa and an I-94, like how long I can stay in the US. It's the easiest example is for a visitor visa. Typically a visitor visa is issued for 10 years, allows multiple entries into the United States, and you can stay for up to 6 months per visit. Well, there's a lot of times that people will argue and complain that my visa is still valid because it's, has 8 more years on the visa. But, they've been in the United States. If they go beyond the 6-month authorized period of stay or admission, they basically become illegal and they start accruing unlawful presence in a lot of instances. And that can lead to ultimately arrest, deportation, and removal. But more likely, it will cause problems when you try to remedy that and re-enter the U.S. on another visa category or classification. You could be subject to bars to re-entry. So again, visas are processed outside the United States and always have been processed outside of the United States. But for an employer, it's problematic. I've got a perfect example. I had a physician that went home or abroad and left on the 12th of January, had a Dropbox appointment, so he didn't have an interview in person, but just had to submit everything to the consulate general. And that should usually have taken about 2 weeks. Well, I get a panicked phone call that we're going to miss our flight because we haven't received our passports. It took almost a month 2 weeks longer than usual for no reason, in order to come get the visa stamped in the passport, get the passport returned, and get on an airplane and come back home. So a lot of times people think it's going to be an easy, quick turnaround. Sometimes it turns into a much longer period. There could be unforeseen circumstances. There might be a name mismatch. There may be a document request that could be problematic. I would almost certainly say, depending on where the individual is born and applying and how old, there might be additional security checks that can delay processing. Back in COVID, we had a client that sent one of their employees home, kind of a late New Year's trip. And then all of a sudden COVID hit in March 2020, and he basically could not come back to the United States for almost a year. We had to get a special exception under the COVID ban and travel bans to bring him back. So this new program the government started last month is a pilot program limited to 20,000 participants. And of those 20,000, you had to have had a visa issued in India or Canada. But they are allowing, or not allowing, if you're one of the 20 and you meet all the criteria, you can renew your visa domestically in the United States while you're here living, working, going to school. So then say you do it now, it takes a few weeks. You have your visa stamp. You want to travel this summer, you don't have to worry about scheduling an appointment. A good example of that is dealing with clients that are trying to schedule things this summer in Paris. And I will admit that I probably was not fully thinking, but there's a big event happening in Paris this summer called the Olympics that basically shuts down the US Embassy in Paris, because I was told that between athletes, coaches, parents, IOC committee members, and sponsors, there's 10,000 people that the embassy's got to deal with this summer for 2 months. So when I had a client, we had everything ready to schedule an appointment. Visa expires in June. She wanted to travel in July. The first available appointment is January 2025. She didn't make that appointment. She went back the next day and made an appointment on February 10th of 2025. So if this domestic visa renewal program is successful and rolled out to more individuals, eligible participants, it will be a very good thing. It's not that it doesn't cost anything more, and it will prevent the cost of an expensive airline flight and potentially delay. Some people can come to the United States one time as a student, go through undergraduate, graduate, get a job, and get a green card and never leave the United States for 10 years. Other people for work have to leave frequently. So having a valid visa and passport is critical. So this is a very good opportunity. We keep our fingers crossed that it will be extended going forward. Next slide. Very quick elimination of passport entry stamps. I mentioned earlier, the visa is the document that allows you to enter the United States. The I-94 tells you how long you can stay in that status in the United States. Historically, when you were on an airplane coming into the country, foreign nationals would fill out paperwork in addition to the custom declaration that they still sometimes make you do. You would fill out an I-94 form that would say, here, I'm coming from this country. Here's my name, my birth date, my passport number. The bottom portion of that would be, you could detach the bottom portion of that. It would be stamped and given back to the foreign national. And that was the paper I-94 arrival departure record. That has gone away. But they traditionally were stamping people's passports. You'd see typically when you enter the US, there's a round circle that has the airport code or the CBP code where you enter the United States, typically an airport code. It'd have the date that you entered stamped, and then it would have handwritten your status and when that status expires. You could confirm that online, and that's the information for an employer. That's the critical information that determines status for your I-9 compliance. Well, they're also starting to eliminate the stamping of the passports. They're now doing electronic scans, and it's going automatically into the I-94 system, which is readily available for anybody. As long as you have the basic information, You can go into the system online. You can enter your name, your birth date, your passport information, and then you can not only obtain your current I-94, which says where you entered, when you entered, what status you entered in, and how long you can stay, but you can also confirm travel history that goes back several years. And you can see when you've entered the US, and you've arrived and departed the US. So where we are is that next slide, Keely, is that this is the new procedure. The CBP website has the website, but why this matters to employers is that the foreign national needs to provide travel history and information, but the government makes mistakes. We've had, family of four comes in over after a summer vacation. It's been a long flight with little children. Everybody's tired, stressed, wants to get through customs. One person hands over all the passports, they go through, and no one ever looks at it. And then all of a sudden, a year later, somebody says, okay, we need to renew our visas. And we find out that, oh, well, when all three of you came in last August, or if all four of you, three of you were admitted for the full 2-year period. One of your minor child was admitted by mistake instead of for 1 year, for 1 month. And that person may, be out of status. And that can cause problems again, as we mentioned earlier, with subsequent visa filings, green card filings, and such. So it's always good to know, and also good to recommend to any foreign nationals, it is not possible for any HR professional or any attorney to constantly track an employee. If it's a business trip, a large trip, employer should know that. But an individual may leave the United States on a quick weekend trip to Canada or Mexico, and you'll never know. But the recommendation is that ultimately it's the employee's responsibility to at least, not, we won't say maintain status, because obviously that requires filings and employer commitment, but to be aware of their status. Does the passport expire? Did you lose the passport and get a new passport? Well, we don't know that. Pull the I-94 after every time a foreign national returns back to the United States, just to confirm that everything is correct. If things are not correct and they're caught early, they can usually be corrected through CBP. What you don't want to see is a 2-year wait, and then try to do something. So again, just a recommendation: anytime a foreign national travels, he or she should pull, then check their status online. Next slide. So here's one of the big two things that we'll be talking about: fee increases. The government, starting on Monday, is increasing the premium processing fee from $2,500 to $2,805. There are some other categories where it's a little bit less, $539, $765 for students, but it's going up across the board. That is what I call, it's premium processing. I call it government extortion. I'm sorry. It's just, if something takes 9 months to process regularly, you can pay $2,805 starting next Monday, and it'll be processed in 3 weeks, maybe 4 weeks tops. Sometimes it's not worth the money. Other times it's absolutely required if someone's status is expiring, or for example, you're trying to hire someone from another company, changing status, changing employers, or sometimes if you need to file based on a green card case, there might be reasons that you have to file, and the fee's going up. It was $1,200 and then has moved up incrementally over time. Argumentally, it's inflation based. So we're now at $2,805 starting Monday. Next slide, please. So the bigger impact is the application filing fees, not the expedited processing, but just the general application for all immigration benefits, family and employment. As of January 3rd, USCIS published a notice of rulemaking adjusting all the fees. The new fees are going into effect April 1st. And we'll talk in a moment, but there are actually not just increased fees, but also some new fees that actually may result in litigation. We will see. So again, the government was saying, just like the post office, USCIS is fee funded. And then with COVID, they had a reduction in their receipts, drops in revenue by almost 40%, depleted cash reserves, temporary hiring freeze. workforce attrition, which is why things are now taking 8, 9, 10 months, and you might need premium processing. But bouncing back, they're hoping that this increase is going to result in significant revenues to remedy these issues. This is no different than the post office raising the price of the stamp, which they do quite regularly. However, whereas a stamp is still under $1, USCIS fees are several $100s, if not several $1,000s. So next slide. Hard to read, but table of fee increases for most common employment-based petitions. H-1B, currently we're paying $460 for the actual application. The fee is going up to $780 in April. Ls are $460, going up to $1,385. I-140, which is part of the employer green card case, is only going up $15. Adjustment of status, which is how you get a green card, sort of the person or employee's application for the green card, is currently $1,225, and it looks like it's dropping, or not dropping, going up, slightly, $215. But what's different is that the current $1,225 includes the $765 employment authorization and $131 travel authorization, which are now separate. So, you're obviously seeing a significant increase in fees. There are some exceptions if you're a minor child, if you're a certain age, if you're a company that has less than 25 employees, you're a nonprofit, there are some fee discounts. But right now, you're sort of looking at the fee increases. The big thing I want to add or note is that there's an asylum fee now of $600, which is $300 if you're a nonprofit or a small company. But that is a new fee being imposed on all employment-based immigration filings with USCIS across the board. And it doesn't benefit any employer or employment filing. It's basically to help them on the asylum fees for processing asylum cases. So for a new H-1B, remember we talked about $460. There is a one-time anti-fraud fee of $500, which has not changed. And now there's a $600 asylum fee. Then, depending on the size of your company, there's a supplemental $750 fee or $1,500 fee. And then with a $2,805 premium processing fee, it's getting pretty expensive to file some of these applications. I mentioned earlier, I think the asylum fee is probably going to be subject to litigation because, again, it's only charged to employment-based cases and doesn't benefit any employment-based case. It benefits the asylum program. It needs to be, perhaps there will be a lawsuit saying it just needs to be equally applied on all immigration applications. And then last but not least, we're going to wrap up with the H-1B lottery and H-1B registration. For the lottery this year, it's $10 a registration per person. Next year, it's going to be $215 to submit your lottery application. So that's quite an increase. So I know we're moving through this to give Chris and Joseph some time, but next slide. We're going to finish up on the H-1B lottery and e-filing. So for those of you who don't know, as I mentioned earlier, H-1Bs are an employment-based visa that is typically one of the most coveted visas because it does not require working for a company, i.e. work for BMW, Michelin outside the United States. You come in as a company transfer. Other visas require you have to be from a certain country, hold a certain citizenship, make a certain investment in the country. H-1Bs are traditionally used by students that come to the US that have no prior connections to any company or anything else. And that's how they can stay here and work. And an H-1B visa is available to foreign nationals in a specialty occupation, which requires the theoretical and practical application of highly specialized knowledge, which is usually acquired by a bachelor's degree or foreign equivalent. That basically is government speak or just legal speak for just saying the job has to be related to the degree and it needs to be specialized and complex. And that traditionally has led to STEM-based degrees being eligible for the H-1B process, i.e. anybody that's an engineer, is applying for an engineering job, that'll work. If you are science-based and you're working in a science capacity, great. Engineering, mathematics, those are the traditional roles for H-1B. There are some additional ones like an accountant, a physician, but generally for H-1B purposes, an MBA in general business or English or history is just not going to be sufficient unless you're a teacher for H-1B purposes. And specifically, the government in some regulation changes is now looking at a close nexus between the degree and the position, because there's been some, people have tried to really stretch, if you're going to be in the IT world, having a business degree is now probably not going to be sufficient. So that's a new change for the H-1B program. We're also going to talk with H-1Bs because that is such a coveted visa, and it is a numerically limited visa. By law, there are 85,000 H-1B visas available per year for new employment. Doesn't count if you have an H-1B or you're working for a cap exempt employer, such as a university or a nonprofit. If you're not cap exempt and you want to hire someone in H-1B status, you have to enter the lottery. In the lottery, there are 65,000 visas that are issued for the regular cap, and then there's 20,000 reserved for those that have a master's degree or higher. So that's the 85,000 that's allocated annually. Last year, there were almost 800,000 registrants for the 85,000 H-1B visas. So obviously you can look at that and say that was a 10% or less selection rate. There was a lot of fraud last year, so they have made some major changes to the program. But for H-1B purposes, the lottery. Why is the lottery there is a lottery because there's excess demand, and the lottery is only once a year. So in order to participate in the lottery, there traditionally or historically, we would file a full H-1B application, submit that application with checks, signatures, and all supporting documentation to the government for delivery on April 1st. That got to be too cumbersome and costly because the government would then have to send back your applications at great cost. So then they started a lottery a few years ago, and that required registration, an online account. It was very cumbersome, and it required back and forth between an attorney and the employer, basically just confirming information, confirming everything, and then the government would notify you. So because of that, the government is basically starting a new, has been developing or have developed a new web portal. Next slide, Keely. So this new web portal is supposed to not only expedite and facilitate the registration process, but it's also going to mandate the electronic or e-filing of the H-1B applications going forward. Initially there'll be e-filing available. There'll also be still paper filing, but the government is clearly going to start moving towards e-filing, which has, a lot of pros, but also a few benefits. But the lottery is always held in March because April 1st is the first date that you can apply for an H-1B, which is 6 months prior to the official start date, which is October, which is the beginning of the government's fiscal year. So although we're looking at the March lottery, March of 2024, it's actually the FY 2025 H-1B lottery. So thus, the lottery is held in March every year. So what's new this year is that there's a new website that has not even been officially released yet and is not available to the public until next week. So there's going to be 250,000 people trying to access that website beginning next week, trying to get set up to start submitting H-1B registrations on March 6th. The registration period runs through March 22nd. The government will notify all registrants by the 31st of March. If you are selected, you will have 90 days to prepare and submit an application for H-1B status with a start date of October 1. Sometimes an individual status may expire before October 1, or employment authorization may expire. The government has extended cap gap, which used to run between say April 1st and October, now runs through April, year-round, April to April. So if someone has expiring employment authorization, and you are selected in the lottery, apply for the lottery, and are approved, that authorization can continue up until the H-1B start date or even longer if there's a problem with the case. So that is coming up, like I said, starting next week for the next month of March. It's going to be very interesting if that website can handle the volume. I'm not holding my breath. I'm sure there's going to be a number of hiccups. The other thing is, it does not appear that it's going to be a drastic overhaul of the current e-filing system, which is very cumbersome and archaic in some instances. It's not as easy as some other websites. So we will be seeing how that works starting next week. Next slide. So we talked about, 800,000 people last year applied. The government said that can't be right. They looked for fraud. They found evidence of fraud in a number of submissions. One individual had 87 separate registrations for different jobs. And the government said, well, we're no longer going to base registration on jobs. We're going to base it on the individual going forward to try to make it fair, more fair. So that will probably reduce the number from 800,000 down to like the 300,000-400,000 range where it was last year, which is not great, but it's still better than a 10%. It should result in better than a 10% selection rate. So we're looking forward to seeing what's going to happen. Like I said, the website opens, or the portal opens next Wednesday. So next slide. So I have talked and rambled and tried to give you some information and some updates specifically with the H-1B program that begins, like I said, next week. I'm going to let Chris cut in and introduce Joseph, but if there's any questions, we'll take a look at the chat, or feel free to email me offline.
Garrett, thank you. Everybody always loves hearing from Garrett. He is probably the only person I know that can add or inject humor into immigration, humor and fear simultaneously. So we always love it when we get to hear from Garrett. All right, so I am excited to introduce to you Joseph Dickey, who is our new law partner and member of the employment team. He just joined HSB this month. And I wanted to tell you a little bit about Joseph. He graduated from Clemson in 2006, USC Law School 2009. And in that short time, he's already been named by Best Lawyer as the 2022 Lawyer of the Year for Employment Law in Columbia. Recognized as during 2021, 2024 for his expertise in employment law and education law by Best Lawyers. Again, recognized by South Carolina Bar Super Lawyers for employment law, labor law, and education and school law 2020 through 2024. He was recognized by the Columbia Business Monthly Legal Elite in employment law and South Carolina Lawyers Weekly in leadership. Joseph is an experienced employment law litigator and advice and counsel advisor to a number of government and private clients, and he's a great addition to our team due to his knowledge and his experience that he brings with him on handling employment law litigation and employment law advice and counsel. Here's some unique things to know about Joseph. He is serving in his second term as a District 4 Councilman of the City of West Columbia. He is fluent in Japanese. Before attending law school, he worked in, and you're going to have to say, I meant to ask you, Joseph, how to pronounce this, Fukuoka, Japan, for an economic development firm conducting market research to assist in recruiting foreign investment. He is on the Casey West Columbia Chamber Board of Directors, and he's an adjunct professor at USC Law School's Civil Litigation Capstone course. So I wanted y'all, I knew he wouldn't tell you all this stuff. It's amazing. But I wanted him to tell you an overview of his experience so that you would know how he can assist you, what type of assistance he can provide. And we're so excited to have him on our team. And then he's also going to touch on recent union activity as a teaser to his April presentation. So Joseph, welcome. We're so glad to have you on the team. So thankful that you've joined us.
Thanks, Chris. Thanks for the introduction. I really appreciate it. It was very kind of you. You're very right. I would not share all that with everybody. It's kind of, I don't know, makes me a little shy. Garrett, thank you for your presentation. I learned some things myself watching you present and listening to the presentation on immigration. Greetings, everybody. Nice to meet you virtually. And just to give you, I guess, a quick overview of my experience, I've over the course of my career, I've litigated labor and employment cases in state and federal courts in and out of South Carolina on the plaintiff side or i.e. the employee side and on the employer side. I've seen anything from the simple single plaintiff wrongful termination case to a class actions being brought by federal government, whether that's the EEOC or another agency. Certain unfair labor practices or unfair discrimination that an employer might have been alleged to have committed. Also, as Chris discussed, I provide advice and counsel daily to my clients, public and private, regarding a wide range of matters, usually labor and employment, but also just business strategy, corporate advice, education, government operations, things of that nature. I try to be just a partner with my clients. I don't like to see it as just this kind of just formal relationship of just attorney and client. I like to see myself as a partner for you to help you work through any issues that may arise, and we work as a team to get to a goal. And usually that works out, and I'm happy to assist you in any of my areas of expertise or at least experience. And if I can't do it, I'm sure I can rely on Chris or someone else in our firm to assist you. So I'm very happy to be here at Haynsworth, very happy to be partners with Garrett, Chris, and the rest of the team. Very happy to be working with Keely, who is our marketing director as well. She has been great since I've arrived. So today, I don't want to get too in depth with what we're going to talk about with the union activity, because this is, after all, South Carolina, where union activity has historically been low. It's not our thing. So, but things have been picking up. People are angry, my friends, and they want to, raise their complaints, and they want to unionize and get together. But more interestingly, is the National Labor and Relations Board decision regarding some student athletes at Dartmouth College that happened on February, I believe it was 5th of this year. And if you see the slide right there, I've given you the case number that you can find on the National Labor Relations Board's website. The Region 1 of the National Labor Relations Board took up a case from the trustees of Dartmouth College versus the Services Employees International Union, one of the local chapters. And it involved 15 male student athletes who played on the Dartmouth men's basketball team. And basically, they wanted to unionize. And the college said, nah, we don't want you to do that. And the players said, well, we have other ideas. And the Service Employees International Union also had other ideas. What ended up happening is the Region 1 held that the men's basketball team, those 15 athletes, student athletes, were deemed as employees or as an appropriate bargaining unit under the National Labor Relations Act, i.e. as a bargaining unit, meaning they are a collection of employees who are working for a labor organization, i.e. employer, and they are able to vote whether or not they want to have a union represent them or not. There's nothing preventing them from doing that. Historically, that has not been the position of the NLRB or of any, oversight agency or adjudicating agency, or more so with regard to student athletes, especially the NCAA. As we all know, student athletes, it's a strict, you are a student athlete, you are not employed, you don't get paid. Well, the recent advents of NIL, names, image, likeness, and other things across the past 10 plus years has started to erode that thinking, and you're starting to see a shift within this view at the National Labor Relations Board and interpretations of employees and who would be considered an appropriate bargaining unit under the National Labor Relations Act. The decision turned on, I guess you look at three factors. I think I said it right. The first of which is whether there was a benefit conferred to Dartmouth College. And when the Region 1 board was looking at benefit, they were looking at things like, does the college receive a financial benefit? Is enrollment increase? Is there more marketing or advertisement that happens because of the men's basketball team? or they're generating ticket sales. And of course, as you would expect, similar to a lot of universities with Division I programs, a men's basketball team, football team, or otherwise is generating those games, and that team is generating a benefit monetarily and otherwise for the university. And so the NLRB held that yes, they were conferring a benefit. Then the other two factors that it kind of turned on was whether the student athletes, i.e., employees, were performing a work for the college and whether they were receiving compensation. Now, if you notice on the slide, we have the infamous air quotes on there because, as you know, as I just said, NCAA and others do not consider, oh, you get if you're a Division I athlete or any athlete that's on full scholarship at a college, they don't consider you as working. You're getting benefit of study halls, apparel, practice, trainers, medical care, and other things, and travel. But that's just, part of you being a student athlete. That's not compensation. Well, the NLRB, at least in this case, said, no, that is compensation. And they started valuing out certain things, like the apparel. I didn't get into the details, but let's say you're at a school that's sponsored by Nike and you're getting Nike sweatpants, you're getting Nike shirts, hoodies, shoes, things of that nature for 4 years. They valued that apparel as over $1,000 per player. And that could be, and it's probably more than that. But that's how they valued that. And they said that was compensation. The extra tutors, the extra transportation and other benefits that the players received. All of that was considered as compensation under this decision with Dartmouth. As for work performed, well, I think we all can see where this is going. The work performed was practice, going to games, playing in the games. And the work performed and the college's authority and ability to control that work being performed is how that decision turned to where these 15 student athletes were deemed employees. One of the interesting parts of the decision is that the student handbook was actually kind of interpreted as an employee handbook in this decision, which we'll get into kind of some more detail in April. But that is, if you're at a higher education institution, that should lead to some concern when you're looking at your student handbook being transferred into an employee handbook with this decision. So that's kind of the gist of the decision here. You can find it by the case number on the NLRB, or if you probably Google Dartmouth and student athletes, anything will come up. So that's the gist of that. We'll talk about that in great detail in April, but just to touch on some just general union or labor information, here in South Carolina, like I said earlier, it's union activity has been picking up, whether that's been from Starbucks or other frontline service line employees at Starbucks, Waffle House, or Bojangles starting to unionize. You've seen these strikes occurring even in Columbia. They're starting to unionize, and if you can go to a map and you'll see that they unionize. You'll see one dispute I was involved in regarding transit employees in Columbia that happened in late 2022 over their hourly wage. So union activity is picking up, and a lot of this is being spurred on by this same union, I believe, that brought this, that was involved in the case of Dartmouth, the Service Employees International Union, at least one of their chapters. And this is starting to become a very serious thing here in South Carolina of bringing back this labor activity, so much so that the governor of South Carolina, Governor McMaster, said in his State of State address back in late January that he would fight the increased union activity to the gates of hell as to prevent it from spurring the economic growth. Now, if you don't know South Carolina, and I'm like to say this, we are very proud of our economic development, and I think we do well at it. But Governor McMaster said, not here, not now, and to the gates of hell we will go to prevent you from getting into a union or anything like it. Well, I don't think people like being said they're going to be fought to the gates of hell. And last week, at least the International Longshoremen's Union went outside of the State House and the governor's office and said they didn't like that comment and they'll fight back. And then actually said that they were well, they didn't have a nice comment and said something about where people will go if they want to fight union activity. But that's where we are in the state. This is kind of a turning point where you're seeing this uptick in labor activity in a state that's traditionally not been one to have that kind of activity frequented or having these kind of disputes. And there are more and more disputes coming, and even for private employers that aren't higher education institutions, you're starting to see also plaintiffs' attorneys filing just general wrongful term or other claims. Instead of going to EEOC, going to state court, they're filing with the National Labor Relations Board and filing a claim under the NLRA, the National Labor Relations Act. Because for at least for private employee, you can articulate a cause of action against a private employer that might not be there under state law under the NLRA, and have the NLRB investigate it, and they will award damages. And that is a situation that no private employer wants to be in, especially if you don't have unionized employees. But that's something we can touch on in April in more detail. I am very happy to be here at Haynsworth. I'm very happy to have joined and become law partners with Chris and the team. I look forward to doing more of these webinars and assisting you all with any of your issues. Feel free to call me or anybody else on the team. So I look forward to building the relationship and just being here and to serve everyone. Thank you.
Thank you, Joseph. That was interesting, and looking forward to hearing more about what you've got to say. So I'll tell y'all, I mentioned this last time, in March, we are going to hear from Ron Scott. He asked me for some assistance some time ago that involved when you can polygraph an employee. He has specific knowledge on how the Employee Polygraph Protection Act pertains to employees. And after working on this with him, I asked him, would he please talk to everyone? So I hope everybody will come in March. And then, of course, Joseph is going to speak to us in April about, in more in depth about union activity. And then we'll hear from Caitlin Beck or either Katie and I in May on a deeper independent contractor analysis, as we promised from January. So we've got lots of things coming up for you through June. Stay tuned. Nice to see everybody today. Have a good rest of the day.
Bye-bye. Thank you.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.